Hello, my dear friends. Svetlana Shlopak, the founder of UKVisaSuccess.com is here. Just only a few days ago, Home Office published an exciting new appendix for skilled workers, which has a number of parts. So the aim of today's video is to guide you through these sections and concentrate on the eligibility requirements. This is going to be a long video simply because there are so many eligibility requirements to understand, but I promise you, if you stay with me until the very end of this video, you will be crystal clear on what requirements you need to meet in order to enter the UK or to remain in the UK as a skilled worker. So let us begin. Okay, here is how Appendix Skilled Worker looks like. So it consists of generally 5 sections. The first one, we have the newly introduced Validity Requirements section. Then we have the Suitability Requirements section, which is slightly amended, but still very similar to what we had before. And then we have the Eligibility Requirements. And there are 2 more. Number 4 is for those skilled workers who would like to settle here in the UK. So this particular part contains provisions which are governing the indefinite leave to remain applications. And the last part is for the dependent relatives of skilled workers. And generally their spouses and dependent children under the age of 18. And this is really, really convenient because before this particular part was in a different appendix, and that brought lots of confusions for those who wanted to bring their loved ones here at the UK. So the plan for today's video is to talk about the validity requirements, the suitability requirements, and the eligibility requirements. And then I'll create 2 separate videos explaining the settlement provisions and the rules for the dependents. Okay, so let us begin with the validity requirements. The validity requirements is when they say that if the application is not made in the appropriate form, then it will be considered as invalid, it will not be considered at all, or it may be rejected. So this is a very important distinction from those applications which are considered and which are refused. So the applications can now be refused only if they do not meet one of these requirements, the suitability requirements or eligibility requirements. However, if the application is not in the appropriate form, which we'll discuss in just a moment, then it will be considered as invalid or reject, or it will be rejected or not considered at all. So first of all, for the application to be accepted as valid, you will need to complete a valid application form, and they here differentiate 3 different types of applicants. The first one is when we have an EU national with a passport with a chip. So if you have a passport which has this sign, this means that you may be eligible, if you're applying from outside, to use this app, which is called the UK Immigration ID Check app. And what this means is that this app, once downloaded on your smartphone, will be able to read your passport. And the Home Office has already successfully used a similar app which was used for the EU settlement scheme applications, those for EU citizens who wanted to apply for a settled or pre-settled status under the EU settlement scheme. So if you have a passport like this means, and you are an EU national, this means you may be eligible to use this app, or if you don't want to use this app and you're outside the UK, so if you are anywhere else but not in the UK, then you will need to apply for what is known as the skilled worker visa. This is the online application, which is convenient to complete, and the application process is relatively straightforward. So you'll need to complete the form, submit all the supporting documents for the application, and then book your biometric appointments. And hopefully you will also be able to download the supporting documents. And if you are already in the UK, so if you're applying for what they now call a permission to stay here in the UK, then this means you will need to use another form. And this is again the online form, which is called the application form for the skilled worker. So this is as far as the online application forms is concerned. Then we have to understand that the skilled workers and the employers will need to follow a certain process, a procedure, if you will, for making these types of applications. First of all, they will need to pay the fee for the application, and they will need to pay the immigration health surcharge. So the immigration health surcharge, as you can see in front of you, so if someone is under the age of 18, they will need to pay £470 per year. And if we have someone who is over the age of 18, then they will need to pay £624 per year. And the total amount, and as you can see, there are some reductions for the students or those who would like to apply under the Youth Mobility Scheme route. So if you're applying for 3 years or for 5 years, you'll need to multiply this amount by the total amount of years. And guys, if you'd like to calculate how much you will need to pay for your immigration health surcharge, you can visit this page, ukvisasuccess.com/skilled worker. And if you request this information, I will provide you with a link to the immigration health surcharge, where you can simply insert your details and it will be calculated for you. And also certain countries will need to provide a tuberculosis certificate test together with the application. And if you'd like to see which countries are under the application to provide these certificates, you can again go to ukvisasuccess.com/skilled worker, and I'll provide you with a link to this immigration rules Appendix T, where they list all the countries which will need to submit the tuberculosis test in support of the application. And then the standard biometrics procedure. Together with the application, you will be expected to upload copies of all your documents to the system once you have submitted the application. And you will need to also provide a copy of your ID, and you will need to provide the original passport when you are going to one of the visa application centers to submit your biometrics. And of course, with every single application, you will need to submit a certificate of sponsorship, which is no older than 3 months. So this is the process. And also you need to remember that all applicants will need to be over the age of 18 if they would like to come to the UK as a skilled worker. And there are certain switching rules which you need to comply with. Switching is a legal process which allows the applicants to switch from one immigration category to another. So for example, if you came here as a spouse or a British citizen, and then your spouse leaves the UK and you would like to remain here in the UK in some other immigration category, for example, as a skilled worker, then you will need to make a fresh application, and you will need to ask the Home Office to grant this application, and this is called switching. There are certain immigration categories where you will not be allowed to switch when you are already in the UK. And these are as follows. So first of all, you will not be allowed to switch if you are here as a visitor, or as a short-term student, or as a parent of a child student, or as a seasonal worker, or as a domestic worker in the private household, or if you are here outside the immigration rules. So if you were granted some type of application which is outside the immigration rules, you will not be allowed to switch. And these were our very simple and straightforward validity requirements. Now let us have a look at the suitability requirements. The suitability requirements is predominantly about making sure that the person who asks the Home Office to allow them to enter the UK will not endanger the UK society. So generally it's all about criminality, about dishonesty, about debts to NHS and some other circumstances which will prevent the applicants from entering the UK because they will fail to meet the suitability requirements. The suitability requirements can be checked in the Part 9 of the immigration rules, which is called grounds for refusal. They have very recently updated this section, and I strongly encourage you to watch a separate video where I explain the reasons for refusal on the suitability grounds, or when the applicant is caught by the general grounds for refusal. You have debts to NHS, or if you have any unpaid litigation costs. There were some dishonesty elements in the previous applications, and that's why the application was refused. Or if there are some criminality issues, you're very welcome to watch this video just to understand how this works. And also, if the person is already in the UK, they say that the permission to stay will not be allowed in certain circumstances. First of all, let's clarify what permission to stay is. According to the definition, permission to stay, it has exactly the same meaning as leave to remain. So that is when the applicant is already in the UK and they are asking the Home Office to allow their application to remain here in the UK for a longer period of time. So this will be refused if the person remained in breach of immigration rules, and that is unless they say paragraph 39E applies. I have created a separate article where I explain the circumstances where the paragraph 39E applies. But just to summarize it here for you in this video, generally the applicant's overstaying period will be disregarded if they remain here without a valid leave for less than 14 days and they had very good reasons for not submitting their application on time, and they can support this by strong documentary evidence. For example, when a person was at the hospital or where someone died, one of their close family members. So this will be one of the circumstances, or where there were some unforeseeable circumstances which were beyond the applicant's control. For example, where we had a sponsor who for whatever reason didn't make the application on time, and also permission to stay applications. So those who are already in the UK and they would like to remain here as skilled workers, the applications will be refused if they remain here in the UK on immigration bail. So these were our suitability requirements. Now I would like us to have a look at the eligibility requirements. Guys, there are many provisions. I do not want you to get discouraged because I promise you, if you stay with me until the very end of this video, you will be very clear on the eligibility requirements and what they mean. Just to let you know that there will be a number of provisions to which I will be referring when explaining the eligibility requirements, which are not going to be in this video because otherwise the video will be 2 hours long. So if you want some additional information, you are very welcome to go to ukvisasuccess.com/skilled worker. They are completely free. I've provided you with a number of links to various resources where you can further check if you meet the eligibility requirements. Okay, so let us begin with the entry clearance requirements. They say that anyone who wants to enter the UK to apply for entry clearance means a visa which you apply for when you're outside the UK. So if you would like to enter the UK as a skilled worker, you must apply for the entry clearance. And what this means is simply you need to get a visa before traveling to the UK, even if you are on a non-visa national list, or even if you are an EU citizen who wants to enter the UK after 31st of December 2020, you will need to go to the British Embassy or to the British High Commission, there, one of their visa application centers, and you will need to follow the procedure. So, and you need to get this permission in the form of the entry clearance in order to enter the UK. And you also need to understand that any skilled worker who wants to enter the UK, they will need to score 70 points. Just remember that the skilled worker is one of the UK's new points immigration system, and there is a separate playlist on my YouTube channel where you'll see a number of videos which I've dedicated to explaining various routes under the UK's new points based immigration system. So and here we have two different types of points. The first ones are mandatory. So mandatory points is where you have no choice but you need to meet them. So there are 50 points which you'll need to score for mandatory provisions. So this is going to be the sponsorship. You need to be sponsored by the UK employer, and you need to have a job at the appropriate skills. So for that you'll get 20 points each, and you'll need to meet the English language requirements at the intermediate level of at least B1. And you will see later this is for all four components, but we'll discuss the English language requirements slightly later. And then we have the tradable points. The tradable points is where you can, as the term suggests, trade, and there are 6 types of categories, and I will explain them all in just a moment. So we have the A, B, C category, for which you can score 20 points each, and also then we have the D, E, and F categories, so you can mix and match those. So that's mandatory points, once again, where you have no choice but you have to score points for these sections, and we have tradable points where you can mix and match. Let us begin with the mandatory requirements, the 20 points for the sponsorship mandatory requirements. And here we have quite a number of provisions. First of all, the person who wants to enter the UK as a skilled worker will need to have a valid certificate for sponsorship. And what do they mean by having a valid certificate of sponsorship? First of all, this certificate of sponsorship will need to confirm your name, and also they will need to confirm the fact that the person is applying under the skilled worker UK immigration route. They will need to have the details of the job, and also contain provisions about the salary, and then we have some further details about the pay as you earn. It should not be older than 3 months. It can only be used once, and it should not be withdrawn or cancelled by the sponsor or the Home Office. And the Home Office in the Appendix SW makes it very clear that the sponsor will need to be authorized to offer this particular job. So, for example, if we have a sponsor who is authorized to invite teachers to the UK, and they are applying for a job for someone to work here as a scientist, unfortunately, despite the fact that all other aspects of application are met, the application will be refused because the sponsor was not authorized by the Home Office to apply for this type of job. And also they say that this has to be an A-rated sponsor, which is on the Home Office special list. If you'd like to have access to this list, go to ukvisasuccess.com/skilled worker, and also the sponsor will need to pay the immigration skills charge. Okay, so first of all, what is the immigration skills charge? This is a special charge which the employer, it should not be confused with the immigration health surcharge. This is called the immigration skills charge. This has to be paid by the employer, and this is for the workers who would like to apply from outside the UK and to work in the UK for more than 6 months, or for someone who wants to employ the workers who would like to work here in the UK for any period of time. And you may ask me how much they will need to pay. Well, it depends on the size of the organization and the length of the employment. For smaller or charitable organizations, for workers who want to work in their first months and who are the first time employers, they will need to pay £364. and for any additional 6 months that will be a reduced price of £192. And if we have the medium or large sponsors, that will be 1,000 for the first 12 months, and then additional 500 for each additional 6 months. And the UK employers will be exempt from paying this charge if they would like to employ their workers in one of these categories. For example, if they would like to employ chemical scientists, biological scientists and biochemists, physical scientists, social and humanities scientists, natural and social science professionals that are not classified anywhere else, and also research and development managers, higher education teaching professionals, clergy, sports players, sports coaches, instructors, or other officials. So if the employer wants to employ someone in this category, they don't need to pay the immigration skills charge. Then we have the next requirement from the employer. This is all about making a genuine application. And what do they mean by this? They say that the decision maker must not have reasonable grounds to believe that the job the applicant is being sponsored to do does not exist, or it is a sham job offer, or has been created mainly so that the applicants can apply for entry clearance or permission to stay. Basically, these three provisions can be combined in one. So they want to make sure that there is a genuine need for this person to work here in the UK. And there are a number of provisions with regards to the third party. The Home Office makes it very clear that the application will be refused if the employer wants to hire the applicant to a third party who is not the sponsor to fill a position, or who wants a person to work in the UK in order to undertake some type of contractual work. And they say here that that is regardless of the nature or length of any arrangement between the sponsor and the third party. This was the provisions with regards to the 20 points for the sponsorship. Guys, these are very important provisions, because irrespective of whether or not you will be able to score the other points, if your sponsor is unable to prove to the Home Office that they meet the sponsorship requirements, unfortunately the application will be refused, and that is why they are called mandatory. So this is where you have no choice, but in this particular instance, the employer will need to comply with these requirements. And then we have the next, as you can see, mandatory points for a job at the appropriate skill level. First of all, they say that the job will need to be listed on the appendix, which is called Skill Occupations. And I have provided you with the link to this particular appendix at ukvisasuccess.com/skilled worker. So you may request this information and it will be with you within less than 60 seconds. And as you can see, they list not only professions, but they also are very specific about the going rates, which we'll discuss in just a moment. And also they confirm whether or not this particular profession is eligible for PhD points. They also state that the profession will need to have a special code, which you will be able to check if you go to Appendix Skills Occupation. They make it very clear that even if you do score 20 points for a job at the appropriate skill level, if you do not score the previous 20 points for the sponsorship, then unfortunately the application will be refused. The next mandatory 10 points is for the English language requirements. Guys, this is all very simple now with English language requirements. This is should be at the level of B1 or above, and very importantly they specify here that it has to be for all four components: reading, writing, speaking and listening. And if you'd like to know how to meet these particular requirements, you will need to go to a special appendix which is called Appendix English Language, and it has a number of various sections which explain whether or not you can be exempt, how you can meet the requirements, and whether or not your country is on the majority English speaking country list, and also how you can meet the English language requirements if you have academic qualifications here in the UK, or if you have a GCSE or A-level exams. And also there will be special provisions for medical professionals. So you're very welcome to request this information at ukvisasuccess.com/skilled worker. Okay, these were our 50 mandatory points. Now let us have a look at the tradable points. Let us start with a very straightforward one, which is called option A. You will be able to score 20 points and meet the requirements for the skilled worker route if you can prove that your salary is at least at the rate of £25,600 and at the going rate for that particular occupation. And you can check the going rates in the same appendix to which I referred earlier. So that is our very straightforward option A, and then we have option B. Option B is for those who have PhD. So here you will need to score eligible points for a PhD, and whether or not, as I mentioned before, in order to score the eligible points, you will need to go to Appendix skilled work occupations, and you will need to check this particular column to see if your profession is there. If you obtain your PhD from outside the UK, it has to be duly confirmed by NAREC UK, and I can provide you with a link to this particular organization at ukvisasuccess.com/skilled worker. And most importantly, your PhD certificate will need to be relevant to the job, and your job will need to exceed £23,040 a year, and it has to be 90% of the going rate for that occupation code. And once again, they remind here that you will not be able to score any points if the sponsor has not scored 20 mandatory points for the sponsorship. That was our option B. Let us consider option C. So 20 tradable points will be for option C, and I call this particular option as STEM 1. So you will get 20 tradable points if your qualification is in the science, technology, engineering, and or mathematics subjects. Your salary will need to be above £20,400 a year. It has to be at least 80% of the going rate for that particular occupation, and no points if the sponsor has not scored the points for the sponsorship. The next one is a tradable points option D, and I called that one as shortage occupation list. So you will be able to score 20 tradable points if your job offer, if your occupation is on the shortage occupations list, which you can obtain if you request it at ukvisasuccess.com/skilled worker. And in addition to your job being on the skilled worker shortage occupation list, you'll need to prove that it's at least above £20,480 and at the rate of 80% of the going rate for that occupation. Tradable points option E, and I call this one as science, teaching, or age. This particular option was drafted to allow new entrants to remain here in the UK and work in their field. So they say that you will be eligible to apply under option E if your job is listed in table 1 of the appendix skills occupation, and you are either under the age of 26, or you are applying as a chemical scientist, biological scientist, and a biochemist, physical scientists, social and humanities scientists, natural and social science professionals not elsewhere classified, or higher education teaching professionals. And also we have here the 4-year route. And what this means that if the application is granted, it must not mean that the applicant's combined permission as a skilled worker or as a tier 2 migrant will be for more than 4 years in total. And again, guys, as you can see here, we have the salary requirements and the sponsorship requirements. So the salary will need to be at least at £20,480, and the going rate will need to be at least 70%. So that was our option E. Let's go further to option F, which I called health and education option. So First of all, your job will need to be listed in table 2, and this is the health and education sector, very vulnerable section at the moment, and therefore it is listed in a separate table, and the salary will need to be at least at the rate of £20,480 a year, and it has to be at the going rate for that occupation, with some exception. Here they give some exceptions for nurses and midwives. Let me explain what these exceptions are. First of all, these exceptions apply to the salary requirements. They say here that they will allow midwives and nurses to receive less than £20,480 per year in some circumstances. And here they are. First of all, where there have been previously held nursing and midwifery council registration and are undertaking the Nursing and Midwifery Council approved program with a view of returning to their practice, and the applicant is working towards their Nursing and Midwifery Council registration, and all of the following applies: that they've passed the Nursing and Midwifery Council's English language requirements and a computer-based test of competence before the date of the application, and they will sit an objective structured clinical examination to obtain their Nursery and Midwifery Council registration no later than 3 months after the stated job offer starts. And if any of the above applies, they also expect the sponsor to confirm that they will stop sponsoring the applicants if they failed to achieve a full nursing and midwifery registration within 8 months. They also here protect the midwives and nurses by requesting the employer to pay them a salary which is at least equal to the appropriate agenda for change band 3 rates, which is stated again at the table 3 of Appendix skilled occupation. So these were our very special rules for the option F when we want to apply in the health or education sector, and this is the exceptions for the salary payments for nurses and midwives. Now let us jump to the next section of the Appendix skilled worker, and it is called consideration of a salary, and this applies to all tradable points options. So if you're relying on any tradable points, you need to make sure that you comply with these requirements. They have very specific rules as to what this salary should and should not include. And they say here that the salary only should include a guaranteed basic gross paid, which is before income tax and including employee pension and national insurance contributions. And the salary should not include one of the following. So the pay which is not guaranteed, so they would like the employers to get a guaranteed pay, and the salary should not include any additional pay such as a shift overtime or bonus pay, and which is in other words the same as not guaranteed income, and also should not include the employer's pension and employer national insurance contributions or any allowances such as accommodation or cost of living or in-kind benefits such as equity shares, health insurance, school or university fees, company's cars, foods, etc., and also one-off payments such as golden halos or any payments relating to immigration costs such as a fee for making the application or immigration health surcharge, and finally no payments to cover business expenses including travel to and from applicant's country of residence, equipment, clothing, travel or subsistence. And there are some special rules to those who would like to work in the UK for more than 48 hours a week. And here they say that if the applicant is sponsored to work here for more than 48 hours a week, only the salary for the first 48 hours a week will be considered. So there is really no benefit for the employer to employ someone for more than that. And the salary thresholds of £25,600, £23,040 and £20,400 per year will apply. The next provision from the skilled worker appendix is for the financial requirement, which is mandatory. And here they say, and this is a very exciting change which was introduced from 2nd of December 2020. They say that anyone who is already in the UK and they remained here for longer than 12 months, they are under no obligation to meet the financial requirements. This means they've already proven that they are capable of taking care of themselves financially, and they are now under no obligation to provide any documents, so they will be deemed to automatically have met these particular requirements. However, if you are applying from outside the UK for entry clearance, so this is a visa application made outside the UK, or if you remained here in the UK for less than 12 months, you will need to meet these requirements, and you will need to prove that you have the amount of at least £1,270, which was in your bank account for at least 28 days. And I would like to draw your attention here that they have very specific rules as to where these funds can be held and for how long. There are other very special provisions with regards to the finances. You're very welcome to inspect this particular appendix, which is called Appendix Finance, and I've provided you with a link at ukvisasuccess.com/skilled worker. The next section is about criminal certificate requirements. Those who would like to work in a special sector, in a special profession, will need to apply for a criminal record if they lived in another country for more than 12 months. So, for example, if in the last 10 years you've lived in 5 countries for more than 12 months, then you will need to apply and get the criminal certificates from all these 5 countries. And what the special professions are, here they are. So I will not be listing them. If you're interested and if you'd like to check whether or not your profession is on the list, you are very welcome to pause this video and go through this list. So these are mainly the professions in the health and education sector. So this is our first section, and then this is the second one, and then we have the fourth one here. These provisions are there to protect vulnerable clients in the UK. This is the last list for the professions where you'll need to get a criminal certificate in order to comply with the requirements. Okay, so if you met all these requirements, what happens next? So if you met all the requirements, the application will be allowed for the duration which is stated in your certificate of sponsorship plus 14 days, but under any circumstances it will be longer for 5 years, and simply because after 5 years you will be eligible to apply for indefinite leave to remain. And as I said, I will discuss the settlement provisions in a separate video, and there will be certain conditions which will be imposed on your stay. It's really important, guys, for you to understand what these provisions are, because if you do not meet the conditions which will be imposed on your stay, the application may be curtailed. Curtailed means it will be shortened, it will be cancelled, and also all your future applications will be in great jeopardy. So make sure that you understand what the conditions are. First of all, as with all applications, there will be no recourse to public funds. You will not be allowed to claim any benefits, and work will be permitted if the applicant in the area which is specified in the certificate of sponsorship. A supplementary employment will be permitted provided the person continues to work in the job for which they are being sponsored, and also voluntary work will be allowed. And they also allow working out of a contractual notice period for a job which the applicant was lawfully working in on the date of the application, and study will be permitted as well. And in certain circumstances, if your country is on a list, you will be required to register with the police, and you will be informed of this in due course when the application is allowed. And this is it, my friends. This is all we wanted to discuss in this video. Feel free to check my YouTube channel, and in particular the playlist for the UK's new points based immigration routes, where I will be explaining all various other UK immigration routes which allow you to enter the UK in order to work or to study. And in my separate videos, I'll be explaining provisions for settlement here in the UK, and for those skilled workers who would like to come here with their spouses and their children. I would like to invite you to visit this page, ukvisasuccess.com/more, where you'll find plenty of free immigration resources explaining various immigration rules. And I also invite you to subscribe to a new, very, very succinct and short newsletter where I'll be updating you on various changes in the world of UK immigration law. And also, I will be sending various exclusive invitations to the members of ukvisasuccess.com community. You'll only be able to get these offers if you are subscribed to this newsletter. Have an amazing week, guys.